We're going to talk to Hans Johnson. He has written the piece, Basic Protection for Families Should Not End at the State Border, for the Seattle Times. Hans, welcome back to the Young Turks.
It's great to be back with you and the listening audience, Cenk.
All right, great to have you. All right, so Hans, tell us how this relates to the state of Washington, these issues, and then we'll get into the larger issue of the, what should apply to different states and state rights, et cetera.
Beginning in 2007, after a long effort to pass some basic recognition for same-sex couples in Washington state, state lawmakers did pass a domestic partnership registry. They went on to strengthen that registry for same-sex couples and their families in each of the subsequent two legislative sessions in 2008 and 2009. A key factor in the lawmakers' decision-making was the story and the case of Charlene Strong. Charlene is now a human rights commissioner in Washington state, a position that she was welcomed into by Governor Christine Gregoire, who was so struck by Charlene's story, as were lawmakers, because it has a simple clarity about the ravages of the Defense of Marriage Act and the denial of basic recognition for same-sex couples. In December of 2006, Charlene and her partner, her wife of 10 years, Kate Fleming, who was a noteworthy books-on-tape narrator and had a home studio in her basement in a relatively low-lying working-class neighborhood of Seattle, were faced with every couple's worst nightmare. Kate was in her recording studio when, due to a series of problems involving some blocked drains, drainage problems in the city of Seattle, and a flash flood that made headlines across the Northwest, was the victim of her home being inundated by the floodwaters that suddenly descended on it. And still in her basement recording studio, from which she did most of her work, was trapped there as an object fell in front of the basement door. She called Charlene frantically, and Charlene raced home, trying, as the basement filled with water, to remove the pins from the basement door. Did remove two of them, couldn't get the third, could not get the door open, and could not get her wife out. EMTs were called by Charlene's and Kate's frantic calls. They had to use a chainsaw to cut through the first floor into the basement, and they had to fish Kate out with a pike. She was unconscious and a victim of drowning. But that is actually just the beginning of the story, because when Kate was rushed to the hospital, Charlene had to chase with her brother, and upon gaining access to Harborview Hospital, she was denied access to Kate's hospital room because she was deemed not next of kin. When she finally had to make a call to Kate's family members on the East Coast, who had to grant her permission after 10 years of a marriage that they were very much supportive of, she finally did get in. She is very clear to say that she was treated with nothing but dignity upon actually being able to get into her partner's room, but her partner soon died. And to compound the injury with injustice, at the funeral home, she was disregarded by the funeral director, who was only too content to take direction from Kate's mom, but to take payment from Charlene. So the story is really one that showcases how the limbo in which same-sex couples can find themselves in. And it was a story that Charlene went on to tell the legislature, which promptly acted. But that, again, is just the beginning of the story. Because in the absence of any federal recognition, in fact, in the presence of DOMA, even the hard-won legislative recognition that same-sex couples have gained in Washington state, under which now more than 7,000 couples have sought some basic recognition and the enumeration of rights and responsibilities, that is built on quicksand, because DOMA at the federal level puts a hex on any such recognitions at state boundaries. So no matter how powerful the protections are in Washington state, and despite the fact that Charlene had to tell her story again in the course of a referendum campaign last fall, which was the subject of a Supreme Court case, as you might know, involving the signatures and the disclosure of the signatures that religious right groups gathered to put the law on the ballot, she was front and center in that campaign, and once again succeeded in swaying not just a lawmaking body, but in this case, the lawmaking body being the whole electorate of the state of Washington, which approved the law 53 to 47. But no matter how victorious and the series of hoops that same-sex couples have had to jump through in Washington State, it is still the case that because of DOMA, those protections don't go beyond state borders. And I think it was very telling in the piece in the Seattle Times. One of the points we wanted to drive home was that it's just like driver's licenses for Washington State residents not being deemed valid in Idaho.
All right, so Hans, let's take that example. So if Charlene was on vacation, same kind of tragedy happens to her partner in Idaho, she just simply would not be allowed in the hospital, no matter how long they've been together?
Well, the tragedy is that it leaves all of this to the discretion of administrators, and it leaves it to a case-by-case decision-making and discretion of people who should not have that wide of leeway to deny same-sex couples such basic access. I think common sense and, in fact, common practice in many hospital settings is to permit such access, and it's only beneficial to good medical decision-making. It's only beneficial to the aid and comfort of the person receiving treatment. There are many benefits that stem from granting such access, and many healthcare workers and social workers are responsible enough to do that. However, there are cases where people, out of administrative fear, of backlash, out of misplaced notions of violating HIPAA or some other regulation, or simple bigotry, deny a same-sex partner such access. And Charlene's is not the only such story. And the fact that it is still subject to such private decision-making and such wide leeway for private bias to creep into such a vital service of great public importance and great public expense is, I think, alarming and should be a major reason why people of all ideologies, I think, express concern, if not outrage, over DOMA's survival.
Hans, you mentioned all ideologies. So, you're basically arguing here for states' rights, right? Because you're saying the Federal Defense of Marriage Act is not allowing one state to recognize the laws of another state. And so, I mean, it's a little bit more complicated than that, but it is a states' rights issue.
It's important. Yes, it's important to raise that because the DOMA passed in 1996, now 14 years old, essentially grants states exemption from something that most Americans consider to be a standard ground rule for American governance, which is the full faith and credit of one state's covenants in another. And
but I hear you on that. I hear you on that. But let me challenge you on states' rights a little bit. So do you think Arizona has the right to pass the immigration laws that they did? They're saying, hey, look, in Washington you want to pass these laws that you're in favor of for whether it's civil unions or gay marriage in Massachusetts or whatever. In Arizona, we get to pass these immigration laws.
No, but to draw out your correlation, I think there is something quite alarming about telling same-sex couples that they have to present their papers in any kind of setting that is potentially onerous and potentially illogical, given that many situations where they are most subject to such scrutiny, they may not have any kind of record-keeping on their persons. Indeed.
But why not the Arizona immigration law?
Had no clothes on at all.
But why not the Arizona immigration law? Why don't they get states' rights?
The immigration policy is a separate issue from this. This is about recognizing state laws that do promulgate and recognize same-sex partnerships, and it's about removing a federal law which is engaged in active discrimination against a whole swath of the American people, and who are vital contributors to their communities and who are vital tax-paying citizens. So it's actually comparing apples and oranges.
All right. Now, I know what you're saying, because you're saying, look, one is application of the laws, full faith and credit in other states. The other one is state versus federal government. I get that.
That's exactly right.
Right. Okay. Now, having said that, look, let me go back to a more central issue real quick along these lines, which is the idea that Alabama says, look, we don't agree to this, right? You pass whatever law you want in California. You want to, say that smoking pot's okay, and then Massachusetts, you want to say getting married is okay, but we don't agree with that, right? So,
and that's fine.
So
states don't have to recognize same-sex partners. That is not the issue. It's not the distinction that I want to be sure is created here. The distinction I'm making is between a federal law which actively discriminates against even those states where we have some basic recognition in law. 5 states now have full marriage equality, as well as the District of Columbia. Several other states have domestic partnership registries. It is unfair for there to be a federal law which provides such hindrance and so actively trammels anything that has been done and hard won at the state level, whether or not states choose within their own policies, within their own procedures, to pass such recognitions themselves.
All right, Hans, let me get clarity on this last thing. And we're talking to Hans Johnson from ProgressiveVictory.com. He wrote about this in the Seattle Times. So in your ideal world, I mean, well, not in your ideal world, but in regards to the Defense of Marriage Act, you think Alabama should be allowed to say, hey, we're not going to be in favor of civil unions. But if somebody from the state of Massachusetts comes and they've actually been married, they have to recognize that marriage within Alabama because of full faith and credit between the states.
Under the terms of a federal district court ruling that came down earlier this month, which we allude to in the piece, issued by no rabid, fire-breathing liberal, but a Richard Nixon appointee at the district court level, that ruling essentially takes out part of the Defense of Marriage Act. It's, of course, been stayed, and it applies only to Massachusetts. But that ruling said that the part of DOMA, there are 2 operative parts. One saying that the federal definition of marriage is that of only one man and one woman. That is part 3. That is the part that the district court judge struck down. Part 2 deals with essentially an invitation to states to not recognize any same-sex marriages conducted elsewhere. It is a open season, if you will, on any partnership protections that are won at the state level. Its aim was to bar the spread of same-sex marriages that might be recognized in one state, originally in Hawaii, where it first surfaced in 1993. But it was a part. It's a key part of the law because it essentially invites states to turn their backs on same-sex marriages. So the key part of the laws, those 2 key parts of the law, are coming under increased fire. And it is part 3 of the law that was actually subject to being struck down on constitutional grounds by a federal district court earlier this month.
All right. Well, we're going to have to leave it right there. Hans Johnson, as always, pleasure having you on, man. We really appreciate it.
It's great to be back, and I look forward to talking more about this issue and others.
All right. Thank you.